Hello, today we'll be talking through the Terms of Use page on Priceline's website. When arriving to the Priceline website, there is not a pop-up with the Terms of Use agreement for a visitor to agree to. You must scroll all the way down to the bottom to click on the terms and conditions for a user to read it. If you go to book travel through the website, a user can click on the terms and conditions to read. Otherwise, it's assumed that a visitor agrees to the terms and conditions when they book. This type of terms of use page is called a browse wrap agreement. A browse wrap agreement is one that has the terms of the agreement on the website itself and are connected to the main page of the product by a hyperlink. The hyperlink leads to another web page that will have the terms and conditions of the agreement detailed. With this type of setup, the terms do not pop up and do not require an action taken by the user in order to continue. That means that the user is not actively agreeing to the terms linked to the page. This causes an issue because the user of the web page must actively click on the hyperlink in order to even access the terms of use and become aware of them. This is a different way of ensuring that user agrees to the terms, and it can lead to potential issues because the website is not requiring the user to take any action. Legal nature. According to Ironclad's ClickWrap Litigation Trends Report, ClickWrap and browse wrap agreements have significantly different enforceability rates. Browse wraps are only at a 14% success rate in recent years. This is because browse wrap relies on implied consent and doesn't require affirmative action for the user to agree to the browse wrap's terms. Ironclad Journal. Browse wrap agreements can only be enforced if they provide actual notice to users of the agreement. Ironclad Journal. For any visitor who is just looking through the website, this would be a hard agreement to enforce. This would be anyone who experiences any viruses on the website, but they didn't actually book any travel through their website, which is talked about in their terms of condition. They talk about their inability to use, unauthorized use of, performance or non-performance of the site, unauthorized access or tampering with your personal information or transmission, the provision or failure to provide any service, errors or inaccuracies contained on the site, or any information, software, products, services, and related graphics obtained through the site, any transactions entered into the site, any property damage, including damage to your computer or computer system caused by viruses or other harmful components during or on account of access to use of the site, or any site to which it provides hyperlinks, damages otherwise arising out of the use of the site, any delay or inability to use the site, or any information, products, or services obtained through the site. There would be no timestamp or proof that the visitor agreed to their terms of use or even knew they existed on this page if they didn't book travel through Priceline. Where the browse wrap agreement is valid is if a visitor actually books travel through the website, as they have it linked that you're agreeing to the terms and conditions if you select book and pay. If a visitor clicks on that link, that allows Priceline a timestamp of when the user agreed to the terms and conditions. At the head of their terms of use page, Priceline says they have the right to amend, modify, or alter this agreement at any time. This introduction to enforce their terms of use would be hard to prove in court if, again, the user did not physically book travel through the website and implicitly agreed to the terms of use. Booking travel gives the visitor and Priceline a date on which they agreed, which can be cross-referenced to the date of what their terms of use was at that time. If they did not implicitly agree, it would be hard to enforce any amendment of their terms of use policy. Overall, I think to save a company from legal worries, a ClickWrap agreement is the way to go. A ClickWrap agreement is different because it is designed to ensure that the user has a chance to see the terms of use, and they must also actively agree to the terms in order to agree. This tends to set up through a series of pop-ups on the website. With this type of agreement, the terms are actively placed in front of the user, so they have to review and agree to them, which means that your website is better protected as a result. This also means that since the terms must be agreed to prior to any action being taken by the user, they can uphold better legally if they ever are needed. Of the two, ClickWrap agreements are more secure and more enforceable. Legal nature. ClickWrap follow best practices while BrowseWrap doesn't. ClickWrap best practices require you to provide every user with obvious notice of the terms they're agreeing to, require each user to unambiguously and affirmatively give assent to the terms of your agreement, obtain user consent whether you modify or update the terms of your agreement, and maintain crystal clear audit trails that show you agreed to your terms and when. Ironclad Journal. If you have any disagreements with Priceline, their terms of use do not allow litigation. A visitor must go through arbitration. Studies have shown that most consumers have no idea that they've agreed to arbitration, and the incursion of arbitration into the realm of products in a particular may be under the radar. Though financial services customers expect to sign user agreements, you don't think of a washing machine as coming with a contract, says Lauren Sanders, Associate Director of the National Consumer Law Center. Mendent 2020. We will use a case study on a result of a mandatory arbitration clause with Gorey versus Wayfair LLC. On June 7th, 2019, the United States District Court for the Northern District of Illinois ruled in favor of retailer Wayfair LLC and its parent company Wayfair Inc. in a way that upholds a web arbitration agreement. Brandon Isaacson, 2019. Much like Priceline, Wayfair LLC has the terms of use link that pops up on every page. It also has the disclaimer that when placing an order, the visitor is agreeing to the company's privacy policy and terms of use. The court first noted that whether an agreement exists is governed by state contract law principles, and Wayfair's terms of use provided that Massachusetts law governed their dispute. It should be noted that choice of law provisions can help internet sellers understand the rules of the road in terms of making their website-based agreements binding, as well as what specific terms those agreements should be included or not included. Although the court pointed out that the binding nature of the choice of law provision, it turned out to be more general legal principles about contract formation to answer the core question. Was there, the court asked, a binding offer and acceptance of an online purchase agreement? The court said that the contract didn't have to be read to be effective, provided the web page presented the consumer adequately communicate all the terms and conditions of the agreement and whether the circumstances support the assumption that the purchase receives reasonable notice of those terms. When you choose what law controls, you ought to look at how cases applying that law frame the issue. If they frame in that fashion, it will be helpful to your cause. The court pointed to decisions that upheld contract formation where a visible hyperlink appeared on each of the pages involved in placing an order, including language at the point of purchase that matched the language presented by Wayfair, that all sales are subject to retailers' terms and conditions of sale. In Gorney and the cases it cited, the clicking of the place your order resulted in a binding agreement being created. The Gorney court rejected the argument that the plaintiff did not see the terms of use, in part because Gorney relied on cases involving so-called BrowseWrap agreements, which did not include a specific manifestation of agreement by, for example, clicking a website button or checking a box. Even then, the court noted such BrowseWrap agreements can be enforceable under some circumstances, but the judge didn't need to reach that question. Brandon Isaacson, 2019. As stated previously, Priceline has the same agreement as Wayfair, so their arbitration clause would uphold in a federal court if someone made travel arrangements through Priceline's website. In general, I think Priceline's terms of use is acceptable. The only change I would make is changing it to ClickWrap, just to protect yourself as a company, knowing people are seeing and actively agreeing to the terms of use, even if they aren't making a purchase on the site.